Honorable Senators, I'm honored to rise today on unceded and unsurrendered Algonquin Anishinaabe territory. I'm speaking today in support of Bill C-40, the Miscarriage of Justice Reviews. I want to thank my colleague, Senator Arnott, a fellow human rights advocate, for bringing this forward. As Senator Arnott has stated, people wrongfully convicted are victims of the criminal justice system. I want to thank all of my colleagues who've contributed to this important debate. Yesterday, Senator Pate highlighted the overrepresentation of Indigenous women who have been wrongfully convicted in Canada. Senator Pate also emphasized that adoption of the bill is the first step in a process to ensure a more equitable justice system. Today, I wish to add to the debate by bringing to your attention 3 cases from my home province of Nova Scotia that also illustrate the need for more equitable access, a more equitable process. 2 of the cases highlight the need for racial equity, and all 3 highlight the need for independent oversight to prevent systemic failures like these. The first case is a clear case of racism in the justice system. In 2013, 19-year-old African Nova Scotian Randy Riley was arrested after a pizza delivery worker named Chad Smith was shot to death in 2010. Randy Riley was incarcerated for 7 years and 8 months. His initial charge rested on witness testimony, which was recanted after the first trial and before the second trial after a, quote, crisis of conscience, end quote, of the witness. Coming from the historical African Nova Scotian community of Cherry Brook, this case of a young Black man highlights the anti-Black racism at play with the charge and the significant time of his life spent incarcerated. The reality of anti-Black racism meant that this young African Nova Scotian did not get a fair trial. And Andy Riley was able to voice in his own words. He was able to voice this in his own words. Randy read the following excerpt as his sentencing, and I will quote, "And I want the family of the victim to know that this miscarriage of justice, I believe, it's not a burden I put on them, but on the court, because I don't believe that I was found guilty beyond a reasonable doubt. Not only that, I don't believe that the verdict supports the evidence that was presented against me. It seems to me that, though I believe, and I think everyone in this court believes, that no one wanted this case to be about race, but inevitably, race is what it has become. And when things come about race, a lot of time they tend to be ignored. And the elephant in the room is race," end quote. Those are Randy Riley's words. The second case I will bring to your attention is one that many people know about, the case of Donald Marshall Jr., a Mi'kmaq man who spent 11 years in prison after being wrongfully convicted of the murder of Sandy Seal in Sydney, Nova Scotia. Donald was only 17 when he was convicted of this murder and sentenced to life in prison, despite the lack of physical evidence linking him to the murder. In addition to that, there is evidence of police intimidation, false testimony given by police, and even his lawyers doubted his plea and did not verify his accounts of the event. This case demonstrates the anti-Indigenous colonial nature of bias on so many levels in the justice system. Even his defense lawyers, who should be presenting evidence to defend him, were not able to conceive of his innocence. In Donald Marshall Jr.'s own words, and I quote, "I am not the guilty one. The system is guilty," end quote. This is a reminder, colleagues, that these individual cases are not isolated incidents. but failures of the entire justice system. The inquiry into Marshall's wrongful conviction also highlighted the fact that the race of the victim, a young African Nova Scotian man, also contributed to this miscarriage of justice. Marshall's case, though, was a catalyst for change in the creation of the Indigenous Blacks and Mi'kmaq Initiative at Dalhousie University, which seeks to address systemic underrepresentation of Black and Indigenous voices in law. I believe the stories we have heard in various debates in this chamber can also be catalysts of change through Bill C-40. By modernizing the review process, this bill has the capacity to safeguard against some racial bias, like the cases of Randy Raleigh and Donald Marshall Jr., to create more racial equity in the justice process. Now, my third case. The name Glenn Assoon. Glenn spent 17 years in prison for the murder of his former girlfriend, Brenda Way. Glenn was an easy target for conviction because of his complex childhood history of neglect, a grade 6 education level, and a long history of alcohol addiction and violence. Glenn's situation is a clear example of the wrongfully convicted Canadians who find themselves failed by the justice system because of their personal circumstances when they are caught at the intersection of poverty and addiction. Honorable colleagues, I support Bill C-40 because I believe a justice system that upholds accountability and equity is possible. I support modernizing the miscarriage of justice review process and creating an independent review body to prevent biases that are built into our justice system. The cost of miscarriage of justice is the harmful impact on the lives of those wrongfully convicted and their families and their communities. I urge you, colleagues, to support this bill to prevent the future miscarriages of justice, to enhance public trust, and to support victims like Randy and Donald and Glenn. Thank you. Asante.
Senator Batters, you have a question?
I do. Would Senator Bernard take a question? Thank you. Senator Bernard, thank you for your speech. During his appearance before our legal committee, the Minister of Justice repeatedly spoke about the overrepresentation of Indigenous and Black people among the wrongfully convicted, and I want to highlight two particular statements that he made. Quote, "What I would expect for the Commission is that if we are going to give meaning to the fact that we need to have commissioners, those commissioners need to reflect the diversity of Canada with particular attention to overrepresented groups such as Black and Indigenous people in this country." And he also said, quote, "Now what we're trying to do with this bill is to take another step in terms of advancing the fight against systemic and anti-Black racism and the fight against anti-Indigenous racism, to be blunt, and advance reconciliation. This bill is one direct way of doing so," quote. So, Senator Bernard, I'm sure you're probably aware that the Mr. Justice Reform report that dealt with this issue, it recommended actually that there be at least one Indigenous commissioner and at least one Black commissioner. But Bill C-40 only requires the minister to, quote, "take into account that situation without any concrete guarantees of any type about that." Given the fact that the Trudeau government did take a considerable period of time to draft this bill after the Reform report was brought out, how do you feel about the fact that they didn't actually put a concrete guarantee about having an Indigenous commissioner or a Black commissioner as part of Bill C-40?
Senator Bernard.
Thank you, Your Honour. Thank you for your question, Senator Batters. Let me start by saying that I think a recommendation that specifically says one Black and one Indigenous can be perceived as a form of tokenism. And my preference would be an expectation that when the commission is indeed established, that there would be particular attention paid, not just one, My hope and expectation would be that there would be more than one person of African descent and more than one Indigenous person represented on that commission.
Senator Batters.
Yes, good point. But what about the fact that maybe it could say at least one or something like that? But as it stands, it's possible that the commission may be set up. The commission is between 4 to 8 commissioners. We'll see how many are actually on the commission, but there is currently, it's possible that there may not be any.
Senator Bernard.
Again, I think language that says at least one would also be tokenistic, so I would avoid that language. I mean, you're right. There is the potential that none of the commissioners could be represented from those communities. I believe that we have a duty. We have a duty and a responsibility to hold government to account. And so the questions would be continually raised around that when we look to see who indeed is appointed. But I would suggest consultations in the process leading to the appointment of the commissioners.
Sénatrice Clément, vous avez une question?
Senator Clément, you had a question?
Sénatrice Clément.
Would Senator Bernard take a question?
Yes.
Senator Bernard, my godmother in the Senate. Thank you for your speech, and thank you for outlining the 3 powerful cases that you describe. We heard some very good speeches around C-40. We heard relevant, compelling testimony at LCJC. I don't think we heard sufficiently about what you raised today, about the anti-Black systemic racism, even what you raised in question period today. So in this country, we now have a Black justice strategy, which puts forward 114 recommendations to deal exactly with some of the issues you outlined around anti-Black systemic racism. This just came out in June. Do you have any thoughts on what the federal government, any federal government, should be doing with a Black justice strategy like that that deals with anti-Black systemic racism?
Senator Bernard.
Thank you, Your Honor. Thank you for your question. And it was an honor to be your godmother. So as a Nova Scotian, I do have to say that justice, the idea for that justice, national justice strategy began with the Nova Scotia justice strategy to bring justice, racial justice to the justice system. The fact that we have this strategy is commendable. And my expectation would be that we would act on the strategy. Having the strategy in place is only one step. But through that step, we create awareness, we have more analysis, we have action, but we also need that 4th A, which is accountability. And so the strategy should hold us all accountable across the country.
Senatrice.